Set. Okay, good morning. I'll now call the Board of Adjustment meeting for April 5th, 2022 at 10 a.m. to order. Good morning, everyone. This morning, the Lewis Board of Adjustment will consider the application of Romeo Galasso, is that pronounced it? Okay. And Mary Galasso for a variance request to allow for a reduction in lot depth and lot size for a proposed parcel of land, tax parcel number 3-35 4.1875.00, 111 New Road, Lewis, Delaware 19958. I will make one administrative note that Mr. Richard Greer Reynolds is not present today, but we do have a quorum. Before we proceed with the application, a few housekeeping matters. The order of the hearing elements. The city building official will provide a brief synopsis of the issue before this body today. Representatives for the applicant will present their case, present witnesses and evidence, and entertain questions from this board. Statements from the public supporting the applicant will be permitted under the time limits outlined. Statements from the public opposing the applicant will be permitted under the time limits outlined. Applicant will be given a brief opportunity to submit additional testimony or evidence in the form of a rebuttal, and the applicant and each objector shall have an opportunity to present a brief closing argument to the Board of Adjustment. We have time limits. The applicant is limited to 1 hour to present a case. Opening and closing statements are usually limited to about 5 minutes, and cross-examination shall be limited to about 15 minutes. Comments from the public are limited to about 2 minutes apiece. So with that, I will ask our building planner, our city planner, Ms. Janelle Cornwell, who is acting as the building official today, to provide us with an understanding of the published notices for this application.
So the legal ad ran in the Cape Gazette on March 18th. The public notice for this application and the physical posting were also done on Friday, March 18th of this year in compliance with the code regulations.
So if we could just have her sworn in also.
Do you swear that the evidence you will give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Promise that everything you gave was as though you were under oath?
Yes.
Perfect, thanks.
Thank you. Do we need to itemize what is in the record, that we're putting these documents in the record
Yeah, so
now?
if we could enter the Cape Gazette notice into the record as Exhibit A, and then if we could enter the application and the plot plan into the record as Exhibit B. If there's no objection to that.
Hearing no objection, so ordered. Thank you. Now, Ms. Cornwell, would you please provide us with a brief synopsis of the application which we're addressing at this meeting today?
So the request is for 2 variances for the property. The property owner is looking to subdivide the property. However, the property does not have 20,000 square feet. The way the property is zoned as R2 is the minimum lot size is 10,000 square feet with the minimum lot depth of 100 feet. It does have the lot width, but however, they're asking for a variance from the lot size and the lot depth. The proposed lot off of University Drive would have 9,342 square feet instead of 10,000, and a lot depth of 99.38 feet, which is just shy of 100 feet. And that is the request.
At this time, I'd like to invite my colleagues on the board to ask any questions of the building official. Anyone have any questions for Ms. Cornwell?
Hi, it's Luke Mehta. Have any comments been received from the public, with either in favor or opposed to this variance request?
We've received no comments regarding the application.
So at this point, will the person or persons who are representing the applicant please come forward? And before you speak, would you kindly give us your name and your address?
Sure. My name is Vince Robertson. I'm an attorney with Parkowski, Yerk, and Swayze, and we are located in Rehoboth, Dover, and Wilmington. So my address is 21161 Camper Head Road for anybody that's interested.
Thank you, sir.
And thank you for the brief introduction in terms of the procedure. If this goes an hour, we're all in trouble. It should be much shorter than that. I just would like to introduce Mr. and Mrs. Galasso. They are here to my right. And as the chairwoman indicated, it is Sussex County Tax Map and Parcel Number 335, 4.1875.00. The mailing address is 11 New Road. Janelle explained the application. I'm going to go into that in a little more detail. I am going to use 3 exhibits that I'd like to hand to Ms. Cornwell, or Mr. Edwards. I don't know which is. Okay. And they're simple. They're the survey that's on the screen right now, and then actually the next 2 are almost identical in nature. Exhibit 2 is a copy of the Sussex County tax map, aerial photos. It just shows the lot lines, just to show what's around there. I think we all know that. And then applicant's exhibit number 3, and they're labeled, shows the Galasso's property. It's zoomed in a little more just to show the dimensions from the Sussex County assessment maps, particularly the frontages or the widths of those other lots. So let me hand those in. Tell you what, I'm going to give one to my client, each one of these, and my clients first. Oops. I can get my fingers to work. There we go. Just so you have those to follow. There's multiple copies. That's exhibit 1. So, as Ms. Cornwell stated, the property does have double frontage on a New Road and University Drive. It has 94 feet of frontage on both sides, which actually exceeds fairly significantly what's required in the R2 zone, which is 75 square feet, or excuse me, 75 linear feet of frontage. So it's a wider lot. And if you look at those exhibits, just visually, you can tell that it's significantly wider than the other properties that are in its vicinity. It does consist of 19,342 square feet. As Ms. Cornwell stated, 10,000 square feet is the minimum lot size in the R2, so it's vastly oversized for the R2 district. We are seeking a variance of 658 square feet from the minimum lot size for the lots in the R2 district, again, so they could divide this property into 2 separate lots, each having frontage on a roadway. That does eliminate the double frontage or through lot, there's a quirk with that too. It's actually what we call sort of a double frontage penalty or through lot penalty. As you all may know, the zoning code creates both University Drive and New Road as a front yard, so they have to have 30-foot setbacks on both streets. If it was just one frontage, they would just have a 30 on the front and 15 on the back. So with that through lot, that in and of itself penalizes them. I think when I do the math, it's about almost 1,500 square feet of setback area that they can't use had they had only a single frontage. So that's the one variance. It also includes a variance for the lot depth along University Drive. And this was sort of a conversation that happened early on with Ms. Cornwell that led to that. It was where to put that middle line. Do we make 2 lots that were slightly non-conforming? Or do we make one lot that's completely legal and then have really minor variances on the other lot? I don't know that there's a right or wrong way, but I think it makes more sense to have one lot that's completely complies and then the other lot that's slightly smaller in size and also basically 2/3 of a foot short in the depth of it. The request for the resulting lots is consistent with other lots in the area, which we'll go through. And coincidentally, Mr. and Mrs. Galasso do own the property adjacent to the subject property. So the variance, I'm going to run through the elements in no particular order that are in your code. Some of those somewhat overlap. So in terms of whether the variance relates to the specific parcel of land and is not shared generally by other properties in the district in the vicinity. Again, this is an oversized lot by almost double in this area and in this district. It is not a circumstance that based on my review of the city's mapping for the middle of the city of Lewis, that is shared generally by other properties in the district. And certainly, it's by its nature, it's bigger than every other lot in the property, whether that's in Pilot Town Park or in the vicinity, whether that's in Pilot Town Park or on either side of it on that stretch between University and New Road, which are either similar to this when you get to the corner or are much skinnier on either side, which again we'll go through. So it is certainly specific to the parcels of land in this vicinity. The uniqueness of the property, it is again unique, that is substantially different from all the other properties that are in the immediate vicinity, given its size. There are a few double frontage lots in the area that are similar to this. All the other ones, again, which I'm going to go through in a moment based on those maps, are quite a bit skinnier. This one is much wider. This one is nearly twice the size of those other lots. Actually, one of the lots, I think, is 46 by 200 feet, which is essentially the same square footage, and that's long and skinny, which is the same square footage basically as the lot we're asking for the variance for, which shows up on that tax map, which I'll get to in a moment. Basically, granting this variance will bring this property as two lots into conformity with the area on the east side of New Road and eliminate the uniqueness of it, given its sort of large size. It sort of stands out in that area. The nature and character of the surrounding property and the zone where the property lines, the variance in the two resulting lots will not adversely affect the nature and character of the surrounding community. Again, it is the largest lot between New Road and University Drive in that section there. The resulting two lots will be consistent with the character and nature of the community and the Pilot Town Park development. It really, when you look at it, it's going to be really similar to the Pilot Town Park development properties. When you go, I guess that would be sort of west of this along New Road and University Drive, it's essentially identical, where there's all those lots that front on University Drive have a common boundary with the lots in the rear that front on New Road. So it's going to be basically just like every other lot in that area. That is, frankly, the character of the surrounding property and that area. It was not created by the applicants. It was an existing property that's unusual given the size of University Drive and New Road. One of the things, too, with New Road, we didn't go back and research, but I suspect may also be a contributing factor to this, is the enlargement that may have occurred over time with New Road by Del Dot as they've come through. That may have affected it and made it non-conforming. But it was not created by the applicant. The need is based on the size and shape of the property. Again, it being vastly oversized at 19,342 square feet for the R2 district. It will not cause substantial detriment to the public good. That's kind of the same as the nature and character of the surrounding property. One of the things with variances that I like to talk about is whether it's going to be visually noticeable to somebody walking down the sidewalk or driving down the street. First of all, it's still going to appear to be a larger lot for that community because of its 94-foot frontage on either side. Again, that's larger than other properties that appear on those tax maps. And it's basically 658 square feet short, which, given the 15-foot front yard setback and everything else, is not going to be something that is going to be apparent to anybody who may look at that lot. Again, it's going to look like every other lot in that area. And this variance won't affect the building envelope on the property. It still will comply with all the setbacks. There's plenty of room to put a new house, driveway, garage, that sort of thing on the property, which you can see because there is the existing dwelling that's not going anywhere that's shown on Lot A of the survey. It also will not substantially impair the intent of the comp plan or this chapter. The comprehensive plan for Lewis, it talks about sort of focusing smaller lots towards the city center, and that's what this does. Now, certainly, it's not as small as some of the lots that are right downtown, more in the historic district, in the center of town, but it is the smaller lot that the comp plan, with these variances, that the comp plan does promote within that area of Lewis. So it is consistent with the comp plan. It's certainly not such a large variance that somebody would say that it's completely inconsistent, or runs afoul of the guidelines that are set forth in the city of Lewis's comp plan. It is also the minimum relief necessary. So that goes back to the conversation that we had with Ms. Cornwell early on about how to draw the lot lines, and I think we resulted, or the resulting survey reflects it's the minimum relief necessary, because we do have one lot that fully conforms and another lot that it only requires a variance for about 2/3 of a foot, and only for that 658 square foot variance on the lot area. Again, the location, it is in a location where other lots have, the adjacent lots, and if you look on the tax map that's sort of zoomed in, you can see this. It's hard to read, but on the front of those lots, it does say, and that's applicant's exhibit number 3. You can see that the lots on either side, and I realize it's kind of hard to tell, but the scale dimensions show that on either side, the lot is on the, well, if you're looking at it, it's the one on the left. That one has 60 feet of frontage, and the one on the right has 46 feet of frontage, which are vastly different from the 94 feet that we're dealing with. And then sort of on that stretch, there's 2 lots with 50 feet of frontage, one lot that's really narrow, with 30.38 feet, another one's 30 feet, and then another is 60 feet. So you can see that we're still quite a bit larger in frontage and in appearance than everything on that stretch, except for if you look on that Exhibit 3, you can see on the left at the top, there are the 2 lots that have 2 houses on them with the driveways on the connecting street. They are essentially going to be identical to what we're talking about here on this property. And just to backtrack a second, if you look at applicant's exhibit number 2, that shows the Pilot Town Park neighborhood in greater detail, and you can see that they have similar lots to what we're asking for, where the backyard boundaries abut one another, and that runs all the way up New Road. It's on the other side of University Drive, continuing throughout that project. So this property will be, I don't want to say identical, but as nearly identical as you can get to those lots in terms of size and appearance. So there is a hardship with this, or an exceptional practical difficulty if it's not granted. As I mentioned, the lot is it's almost double the size of what's required. So they have almost 10,000 square feet that there's no useful benefit of, and that they would like to be able to subdivide and create another property on. The other thing is, I think the big difficulty is the fact that it's double frontage. I know in land use, that's sort of frowned upon because it does create a decision, what's your front yard? Is it, if you're trying to design where to place a home, is it University Drive or New Road, just from, which place you're going to have an entrance to, or which side you're going to have an entrance to. But you're really penalized by that double frontage setback, the 30 feet on either side, because with having it a through lot, your backyard in terms of what you can place in that backyard is substantially diminished, because it becomes, well, for example, in this case, if on the survey, the front of the house is oriented towards New Road. That means that there's a large building lot setback on the University Drive lot, which would go down to, or the rear yards would be reduced to 15 feet. Right now they've got 30 on each side. So having 2 lots would be consistent with the 30 and the 30 and then the 15 in the back. So that does create a hardship with the existing property that would be eliminated, and it would be consistent with the other properties if the variances are granted and the lots are split so that there are 2 lots on this property. So that basically concludes my presentation. We would ask that you act favorably upon this variance application because it does not adversely affect the area roadways, the neighboring adjacent properties, or the community in general. It will allow an additional lot to be created that is essentially identical to both, or to others in the area. We do realize we're going to have to go through the subdivision process with Ms. Cornwell and the Planning Commission if this is approved, so this is not our last stop with regard to this. But I also like to point out it will have an economic benefit to the city of Lewis. If there are two lots there, that will create additional transfer taxes, presumably permit fees for building permits and that sort of thing, and property taxes that may be generated by having an additional lot. So with that, I would like to call up, I guess, Mr. Galasso, if you want to come forward.
Sure.
And you will need to be sworn in by Mr. Edwards.
Mr. Galasso, do you swear that the evidence you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
First of all, Mr. Galasso, you've heard all the testimony that I have, or excuse me, all the explanation that I have given this morning. Do you agree with everything that I have stated? Okay. Is there anything you'd like to add to that?
No, I mean, we're just, we've been, we started out vacationing with our kids in Lewis, so we've been in Lewis forever, I guess. We started out right in Port Louis, and then we ended up buying, and then I got tired of going up and down the steps. So we found this house, which we live in now, and so our neighbor next to us that always wanted me to purchase the house, she was very nice to us. Sharon Walsh was so that's how we ended up with this property, not knowing that it was such a large, it was. So my wife and I, we're not going anywhere. We're going to be in Lewis, hopefully, for a long time. But we have 3 boys, so we thought maybe down the road we can leave each one of our child a parcel, that we have 3. That's our main reason that we're trying to do this. We have no other interest in building, selling, or anything like that. I mean, we just, and if it's all possible that we can get this through, it'd be very greatly appreciated that our kids will someday benefit from us. That's about it.
Okay. Well, and you heard me, just because you live there and know the property, you heard me talk about the nature and character of the surrounding property,
Yes.
like Pilot Town Park, so the other lots. If these variances are granted, will it be consistent with the character of that area?
Absolutely,
Okay.
absolutely, yes.
Are the lots in Pilot Town Park and the homes in Pilot Town Park similar to these 2 proposed lots?
Yes.
Okay. Really, that's all we have this morning. So we're certainly available to any questions, and I know you need to see if there's any
Yeah.
opposition here or online as well.
All right, so I'd like to invite my colleagues on the board to ask any questions they might have of either of you. Colleagues, questions?
I have questions, but I'll happy to defer to others.
Bill? No?
I have a few questions.
Sure.
Vince, I heard you say that the applicants own an adjacent parcel?
They do.
On this map, which one is it?
Oh, okay. Let me just orient myself real fast. Which one were you looking at, Exhibit 2, or are they both the same?
Okay,
But-
it's Exhibit 3.
Exhibit 3.
Is it the one that also just has one building
because
on, or is it the?
You can see it on the survey.
Yeah, it's the one on the survey, which is reversed from the photograph, because University Drive's on the bottom on the
One
photograph.
to the left of the
The arrow?
property in
Yes.
question. Okay.
And Mr. Galasso had mentioned that that a neighbor had encouraged you to, I forget actually what your testimony was. A neighbor had encouraged you to do the subdivision, or encouraged you to buy the property, or?
When we first moved to this house that we live now, she was very, very nice to us, because we were trying to, actually, we were trying to put a pool in, and the inspector from, came, and
She tried, she
Hold
wanted
on.
at the
We-
mic. I'm sorry.
You can come on
Oh, come
up,
up,
we just need to
just
get
come to the
sworn in.
microphone because it's being recorded. They need to be able to hear you, dear, okay? And I need to swear you in. Do you swear that the evidence that you will give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
When Sharon lived there, she had looked into it, but she just didn't have the financial means to go in and do that. But she told us that if you can afford to do it, it could be done. This is what she told us years ago.
And
So-
that's what happened. She was very nice to us. I mean, that's the bottom line. We were trying to put a pool in, so we had the inspector come out to our house, and it was an older gentleman, and I still remember it, told the guy, where are you going to put this pool? So we got a real small pool that was, we were able to put it in. Yeah,
You own this one? And this one?
yeah.
And Sharon owns this one? Which one does Sharon own?
This is
This-
the lot we're talking about.
Right. And this one that you already own as well, with the
Yes.
pool. And then, is this Sharon's property here?
No, this is Justin Bartel's. This is the property. we're
Right.
talking
Where
about.
does Sharon live?
Sharon lived there. This is
Oh,
what
she
we
used to
purchased.
live there?
Yes.
You bought it from her?
Yeah.
Gotcha.
That's how we became really good friends. She let us borrow her property for the equipment, and we didn't know too many people, so she was very, very helpful to us. And we just became close, and she was very nice. And I was so grateful to her that she had this old car in the middle of the park, the lot, that didn't run, and she loved the car, and it didn't run for years, so, and I guess she couldn't get nobody. So I have an auto repair shop. So I told my wife, I'm gonna take this car to our shop and just rebuild the whole car for her and surprise for her, just to thank her for what she did. And I did, I took the car and then I brought it back. And so we became very close. Then she got sick, and at the same time, I got sick, and she always told me that she wanted us to buy the property from her. And that's how it all came about. And then, and I said to Sharon, I said, I'm gonna buy this, but you have to be alive. I'm not gonna wait till something happens. And so, and I said, you do whatever you need to do. So she contacted her, I guess, ex-husband, J.B. Walsh. He could read over, she used her own attorney, and we made an agreement. And the agreement that we made with her was, we don't care. We buy the house, you stay as long as you live. We don't care. We don't. So she stayed there till she passed, and we became very close to her. So we're not going anywhere. We're not going to sell our property. We're not, we're there. We're here to stay.
Been there
We just-
17 years.
We just want to, if it's all possible to get 3 places, we have 3 boys, and that's our intention. So
So I'm just trying to figure out who's on first. So you own this property, this is the property, who owns this property here?
Justin Bartel.
And what do they think about your plan to see a variance?
We tried
I just need
this.
you back at the mic, please.
So you picked up on the recording.
We tried it several years ago with another attorney, and he ended up passing away. And I immediately told Justin our plans. I said, we have no plans. We're not going to sell. We're not. And he knows the sign's been in the yard, and we haven't heard anything, other. We're on good terms with him.
And it's not your current intention to, you want to create a separate lot, but it's not your current intention to put another building on that?
no, for now, I mean,
We have no
just-
plans right now.
Yeah.
And you bought this lot in 2017?
No, we bought it. We've had
17
it.
years ago, I think is what.
Oh, I thought the thing that in 2017.
109, are you talking about?
With a lot at issue here.
We've been in our current home for about 17 years.
Okay.
And
And
then we purchased that maybe 5 years ago. The 111, the one we're talking about.
yeah, you purchased that one 5 years ago, right? And have the dimension, I mean, it's the same dimension today as it was 5 years ago when you bought it, right? Okay. And in your your words, what is the exceptional practical difficulty presented here and why you're seeking the variance?
While we're here, well,
What is the exceptional practical difficulty, which is the basis for your request for a variance?
well, we talked to our kids, and, we, looking around, it's a big lot, and, and the kids are very interested, so if they could have each someday a part that they could do whatever, if they want to, if we want to build another house, we have 3 houses, we have 3 kids, and
I
that's
think
the
what
main
you're
thing.
saying is, do we foresee a problem, or is that what?
Now, what I'm doing is the standard, and your attorney can talk to the legal, but I'm trying to get the facts of the standard is, and you would have the burden of demonstrating an exceptional practical difficulty, which is the basis for your seeking the variance. And I'm just trying to get you to put in your own words, what is that exceptional practical difficulty, which is the basis for your request for a variance?
I mean, I don't see any.
Well, I think what Mr. Galasso, he hit the nail on the head when he stated that it's an exceptionally large lot. They're sort of penalized in the city by the town code of having a large lot when the comp plan talks about wanting smaller lots. And they're, but for 900 square feet, they would have 900 square feet and 2/3 of a foot. They would have the ability to put another home for one of their children on that lot. Plus, I mentioned there's, and this goes back to what Mr. Galasso stated, given the large lot, with the double frontage, they're faced with that, double frontage penalty with the rear yard having a front yard setback requirement.
And there's no present intention to build another building on the
We
lot that fronts on University Drive?
don't have any plans.
Okay. I have some questions for the lawyer, but not for the applicants.
Thank you. You may take your seats. Thank you.
Mr. Mehta, one of the things, I don't know that whether they want to build a house on the property at the present time is all that significant. They do want to subdivide it, which they're entitled to do under the code, request a subdivision if we get the variances. As we all know, codes change, and for estate planning purposes, I think it does make sense to try to do that now versus, wait and see what may happen with the city's code, with the zoning districts and the dimensional requirements and everything else down the line. So whether or not they want to build a house on it right now, I don't necessarily think is all that significant to the variance application. So. Anyhow, was there any other questions?
Yeah, so you mentioned the comprehensive development plan, and what about the provisions in the comprehensive plan that talks about maintaining open space? Is this consistent or inconsistent with that goal of the CDP?
I think that is inconsistent with, and I do recognize that's in the CDP. And the way I've always sort of viewed those requirements for open space is that they're in the design of subdivisions. In other words, that's community open space, whether it be common areas or, recreational areas within the subdivision, or, lands that are dedicated to the city of Lewis to be used by the city's residents as open space. I don't consider, and I don't think the comp plan, the CDP, considered backyards to be open space. That kind of goes down a rabbit hole if we're going to start requiring open space on individual lots for the benefit of the city, whether or not that's a taking or not. I understand the question, and it's the point taken, but I don't transpose open space requirements in the CDPs to people's individual properties like this.
My second question.
And it's not. And let me back up to another part to that is, we would fall into that category if we were looking to do a major subdivision, because then there would be open space requirements that would be incorporated into that. With this being a minor, there wouldn't be any open space requirements.
My related question is, what's so wrong with being unique? In other words, one of the beauties, it seems to me, of Lewis is its unique charm and that different properties are different. And as I understand, one of your arguments is you're seeking the variance to eliminate the uniqueness, to make everything look exactly like the neighbors. And what I'm trying to get at is, what's so wrong with the property remaining unique? And isn't that also something that the CDP talks about in terms of maintaining the charm of Lewis?
Wow, okay, that's a loaded question. So.
Here.
Yeah, no, well, first of all, I have to deal with the uniqueness because that's one of the standards that's in your code and it's in state law and it's in all the Delaware court cases that, like Quick Check and everything else that have talked about variances. So if I didn't talk about uniqueness, I wouldn't be making a record this morning. So that's the first part of the question. The second part of the question is, what's wrong with uniqueness? So I think based on what's in the record with the maps and the survey and general knowledge and the CDP and everything else, this is unique in the wrong way. It's a large lot that doesn't have any, the way it's set out, it's not a historical property, anything like that has any significance of it being, 20,000 square feet. And the CDP talks about the desire to promote smaller properties in the city of Lewis. The uniqueness of this is that it goes right the opposite from what the CDP says with being a 20,000 square foot lot when everything else out there is 10,000 square feet. So it's not unique in a good way. It's kind of unique in a way that just sort of sticks out, not necessarily in a positive way. But back to your original question, and I do understand asking about uniqueness, but that's the fundamental basis for granting a variance. We have to show that there's something unique here, so it's not like every other property, so we could get the variance if you also deem it appropriate.
No, I understand that, but it's the reference to the CDP that I'm asking about.
Yeah.
And then, again, I'll give you one more shot. How has your client met the burden of demonstrating, as required by Delaware law, exceptional practical difficulties when there's no present intention to build a lot? And this is, and I'm not questioning the genuineness of the goal is to set up a financial plan to benefit heirs. But do you have any authority for the notion that meets the definition and requirement for exceptional practical difficulties under Delaware law?
Well, certainly it does, and I think, Mr. Mehta, you're focusing on variances that would apply to a setback or a building. That's one kind. We need the variances because they're entitled to apply for a subdivision. They can seek that, and if they get that, they can seek to build a building permit on it. So the right that's generating the need for this variance is to go forward before the Planning Commission and seek a subdivision. It sounds more like the type of question or the concern you have would be if I came in and said, and these lots existed, let's say hypothetically these lots existed today, and they came in and said, I want to build a building on here, but it's going to need to encroach in the front yard setback by 5 feet. Then I think that's a reasonable question. You'd say, well, do they have plans to build a house? And if I said no, they don't have plans to build a house, then there's no exceptional practical difficulty in seeking a variance for a house that's not yet planned, nor does it exist, nor do we have any intentions to pull a building permit. In this case, the exceptional practical difficulty is the fact that this lot that's in substantial compliance with the zoning code cannot move forward with a subdivision, not a building permit, not a home, not a dwelling, but a subdivision, which we need to do before the Planning Commission. And the exceptional practical difficulty is the fact that there's 2/3 of a foot short on one lot and 900 square feet on the other that's holding them up from getting 2 lots just like all the others in Pilot Town Park that are in this area. So on a lot that's twice as wide as some of those along New Road and University Drive, and 30 to 40 feet wider than all the other double frontage lots that are on University and New Road. So,
And I get that it's a legitimate and understandable desire and goal. I understand that it's awkward. I get that nobody's opposing it. I get that folks, hold on, let me just finish. And I get, the neighbors don't seem to be objecting, but one of the elements is to demonstrate, and your client has the burden of demonstrate exceptional practical difficulties, and I think the testimony is these folks bought this lot 5 years ago or 6 years ago and hasn't really changed much. So I'm struggling with the exceptional practical difficulty, so I'm trying to give you every opportunity to address that, at least for me, if not for my colleagues on the board.
well, and they bought that lot 5 years ago, and I would say the exceptional practical difficulty has existed with regard to that lot for quite some time, at least as long as the R2 zone required 10,000 square foot lots within it, because that one made this, the big elephant in the room, or in the neighborhood, because it is double the size of everything else. They didn't create that when they bought it. The zoning code created it when every other lot in the Pilot Town Park has dimensions that are similar to this in frontage, width, and depth. As both of these lots. The exceptional practical difficulty is that, but for, the 600 square feet and the 2/3 of a foot, they'd be entitled to do what every single other one of their neighbors are. And as I said, plus they have the double frontage penalty that none of their other neighbors have in Pilot Town Park. So.
But the neighbor to the left, like that'd be 113 or 1.
Or are you looking at the
Yeah, I'm sorry, this one.
Yeah.
I'm going to apologize. But your neighbor to the left, Mr. Bernie or whatever his name was.
Bartel.
I guess it's his lot, Bartel. It's narrower, but it's also as deep, and he doesn't have the building in the back. Maybe his square footage is significantly less than 20,000.
Well, the neighbor.
Because of the narrower width, but
Right.
but there's no building behind his lot, is there?
There is not, because he's chosen not to build on it, and also he's got that 30-foot front yard setback that he's got to deal with, which prevents him from putting anything in there. The property on the right, which is the Galassos, that's actually, so we're asking for a variance for 9,000, well, the lot area would be 9,342 square feet. When you do the dimensions on the one to the right of it, the one with the pool, that's 46 by 206. That works out to 9,400 square feet. I mean, so again, that lot is the same and it's undersized in the R2, as square footage wise, but for a couple of feet is what we're asking for Lot B, the one that fronts on University Drive. Thanks. What Ms. Cornwell's put on the maps is the same thing as what you have as exhibits 2 and 3. Mr. Galasso, did you want to add anything?
Yeah, I would just,
Please step to the microphone, Mr. Galasso.
I don't understand the question, the question you were asking. Can you explain that to me, please?
Sure. The standard for seeking an area variance, which is what you're seeking,
Yeah.
includes as one of the elements for you to demonstrate to the board that there's an exceptional practical difficulty.
What does that mean?
Because I know you're asking him a legal question.
Well, no, I'm answering your question and
So I'll explain what that is. So the criteria that we went through are what generates an exceptional practical difficulty by state law, as I've talked to you and as I'm sure the board knows. We have to show that the property, and I'm going to just run through all these because it's based on what's in your code, that the property is unique, and we've talked about that. When you look at that tax map, there's no other 20,000 square foot lots anywhere around there, except for the ice house, which is in its own category altogether. The variance relates to a specific parcel of land and not shared generally by other properties in the district or the vicinity. Same thing. The variance relates to this property because it's just shy of 20,000 square feet. There's no other property around here, and I don't know if there's any in Lewis, where this type of variance could be requested. That's part of the exceptional practical difficulty. You have to look at the nature and character of the surrounding property, which we've done. What we're asking for is it to be considered consistent with everything else around there in Pilot Town Park. It'll actually be more conforming than some of the other properties in the neighborhood, including the one to the, I guess, east or north, which is identical to this one, and long and skinny. It doesn't even comply. So here's the other thing. None of those lots between New Road and University Drive comply with the lot frontage requirements, the 75 feet in the R2 zone. Both of these are going to comply with that completely. So as you're standing on University Drive and you're standing on New Road, you're going to look at these lots and you're going to think they completely comply because they're 94 feet, when they only have to be 75 feet, and everything else around there is anywhere from 40 to 60 feet, which is fully not compliant with R2. It's not created by the applicants. That lot predated them in size and dimension. It will not have a substantial detriment to the public good. That's the exceptional practical difficulty test in your code. And it will not substantially impair the intent of the comp plan for the reasons we stated. So I understand, Mr. Mehta, your questions, but that was the presentation. Those are the standards for an exceptional practical difficulty. And it's the minimum relief that's necessary. So.
I don't have any questions.
I'm fine.
Thank you.
Okay.
Okay. Are there any folks on Zoom to participate in our process today? There are not. Are there any folks in the public who would like to speak about this? No. Okay. So at this time, I'd like to invite my colleagues to have a conversation about what they've heard today. We can start with a motion and then go into the discussion. So can I hear a motion regarding this application, and then we'll go into the discussion phase?
I move that we approve the application as submitted.
Thank you. Can I hear a second?
Second.
Second. Discussion.
Well, in my view, I did agree with the elements touched upon by the attorney in the presentation. Moreover, it's really a very minimal request for variance, I think. And as a homeowner and a father, if I had the opportunity to do what they're wanting to do, and I was unable to do it because of a few hundred square feet, I would find that to be a very serious practical difficulty.
I live in Pilot Town Park, and I do think it's similar to a great many lots there. I worry about Lewis losing its uniqueness in general, and what's happening on New Road is certainly contributing to that. This seems, I don't want to say like a nothing thing, but compared to what's going on in the rest of the city, this is a very small request for me.
Mr. Mehta?
I'll give my reasons when we take
Take the
the vote, but my only comment here is, and I don't want the applicant, because I'm going to vote in favor of the request, and I'll tell you why in a minute, but for purpose of the comments, what I'm trying to do here is instill some greater factual and legal rigor to the process of seeking variances. And variances should be granted rarely. They're the exception, not the rule. I think there is a basis for the variance, and I'll tell you again why I'm going to grant in favor. But what I'm trying to accomplish through my questions, my comments here, is to add rigor to the process, because I think this town, I'll just speak for this town, we have to make sure that when the board does act with regard to a variance request, it does it for the right reasons, as opposed to willy-nilly.
Mr. Mehta. So we do have criteria to make our decision, and they've been articulated by your attorney, but I'll just review for you some of the criteria that we're obliged to look at, and what is required, and then what is looked at in balance in terms of the decisions that we render. That the requested dimensional change is minimal, and from the standpoint of the square footage that you are requesting, it appears that that is a minimal amount given the overall size of the parcel. The question of the harm to the applicant with denial is greater than the probable effect on neighboring properties if granted. The harm to you in this instance will be that you're asking for the ability to divide this parcel into two parcels, and that's, something Mr. Mehta is trying to address in terms of the practical difficulty. Have you answered that question? That your practical difficulty must be actual and not theoretical, and that it must not be a routine question. Other things that we're obliged to consider are the nature of where your property resides, the character of the immediate vicinity, and we've seen through the exhibits that have been provided to us the neighborhood and what it looks like. We can see the visuals from the overhead imagery, as well as the plot sizes of the neighboring properties. And so, based upon what has been presented today, I will vote in favor of your request today. But in order for us to take a vote, we will poll each member and ask each member to give their reasons for why they vote in the manner that they do. And so I'm going to ask Mr. Sharkey to vote first.
Okay, I vote in favor of the motion. And the reason I did it, basically, Madam Chair, what you were saying about the uniqueness and so on. I think while I don't live in Pilottown Park, I'm very familiar with it and have a couple of friends that live there. Granting this is not going to affect that neighborhood one single bit, in my opinion. And as I said, the inability to subdivide as a matter of future planning is, in my view, a hardship. So.
Thank you. Mr. Mehta?
So I'll vote in favor of the variance request for the following reasons. I think it clearly relates to a specific parcel of land. I think there's no opposition here, so the variance can be granted without substantial detriment to the public good in this neighborhood. I think it's probably a closer call, but I think you established it, and there's certainly no opposition that the benefits from granting the variance would substantially outweigh any detriment, and certainly in the absence of any testimony to the contrary. I also think it's a close call, but I think it's been met here, that approval of the variance would not substantially impair the intent and purposes of the comprehensive plan. The board also has to take into consideration the character of the immediate vicinity, and I think we have done that. And finally, with regard to specifically, which was my probing question on exceptional practical difficulties, and I'm trying to set a record here for you. Again, I think we've looked at the nature of the zone of the property, R2, and you've demonstrated with the zone where the property lies. You've demonstrated the character of the immediate vicinity. whether all restrictions, if lifted, would affect neighboring properties. There doesn't seem to be any evidence, any impact on neighboring properties. Again, I think that the last one that I struggle a bit with, but I think you've demonstrated, certainly in the absence of any opposition, whether the restriction would create a hardship on the owner in relationship to normal improvements. So for all of those reasons, I will vote aye in favor of the motion to grant the variance.
I'm going to vote in favor of it as well. I'm moved that there are no comments from your neighbors or from the public in the surrounding area. I do think it conforms quite well, or will conform quite well, with other properties in the area, certainly in Pilot Town Park, and I see no detriment to the public good in granting the variance.
And finally, I vote yes to approve the request before us today for all the reasons stated by my colleagues in terms of the requirements that we are asked to meet, with the dimensional change being minimal, the harm to the applicant, if denied, would be substantial, and that the difficulty is practical and not theoretical. I vote yes. And that concludes our business for today. And so I close out this Board of Adjustment meeting on the 5th of April, 2022. Thank you very much.
Thank you. Well, you put me through the ringer.
I'm not trying to put anybody through the ringer. I do feel strongly that town, that's fine. I do feel strongly that, these decisions